Hello, my name is Caroline Caligari and I'm Special Counsel in the litigation team at Sharrock Pittman Legal. When it comes to business matters and contract law, a question we are often asked is, are verbal agreements legally binding? We make agreements with friends and colleagues every day. So what is a verbal agreement in a legal context? A contract is an agreement between two parties that is intended to be enforceable by law. Verbal agreements are contracts that have been agreed by spoken communication. What makes a verbal agreement legally binding? Similar to a written agreement, a verbal agreement is binding if the following four elements are satisfied. 1, where an offer is made and this offer is accepted by another party. 2, where something of value is exchanged for a promise. 3, where the parties fully intend to enter a legally binding agreement. And 4, where the parties have the legal capacity to enter into the contract. The issue with verbal agreements is that it can be very difficult to prove that a verbal agreement exists and what was agreed. Problems can also arise where parties have different recollections of what was agreed. There is also the risk that a party may be untruthful about the terms of the verbal agreement. We have provided some tips to consider before you enter a verbal agreement and steps to take after a verbal agreement has been made. If you are a party to a verbal agreement or want to protect your agreement, please do not hesitate to contact a member of our team. Our lawyers can provide advice on how to ensure that any verbal agreement is legally binding. We're on your side.